You scrubbed the hard drive and burned the clothes. That isn't panic, that is calculation.
It's called cleaning up a mess.
I was actually trying to hide something. You wouldn't be standing here asking me stupid questions.
On the morning of March 22, 2022, Thessaly Harris was bludgeoned to death in her backyard apiary in Austin, Texas, struck 7 times with a garden rock that shattered her skull and ended her life among the bees she'd lovingly tended for 14 years. The killer was her own son, 17-year-old Breck Miller, who murdered his mother with the kind of calculated brutality that would later prompt a judge to call it the worst case I've seen. What made this matricide particularly chilling was not just the violence, but the cold planning behind it. A months-long scheme detailed in a 23-page manifesto, an elaborate alibi constructed 40 miles away, and a complete absence of remorse that would shock even seasoned investigators. The crime appeared perfect, the teenage killer seemingly untouchable behind his airtight story, until Detective Indigo Garcia noticed something impossibly small stuck to the bottom of his shoe. A single dead honeybee that would become the most damning piece of evidence in Texas criminal history. Before we continue with this devastating story, I want to ask you to hit that subscribe button if you're finding this coverage compelling. Drop a comment below and let me know where you're watching from. It helps us understand our community. Now, back to the horror that unfolded in that Austin backyard on what should have been an ordinary Tuesday morning. The crime scene told a story of sudden, explosive violence that seemed at odds with the peaceful suburban setting. Thessaly's body was positioned between hives number 7 and 8, according to her meticulous labeling system, with a bloodied rock from the nearby garden bed lying 4 feet from her head. The medical examiner would later determine she'd been struck 7 times with enough force to cause immediate unconsciousness after the first blow, meaning the subsequent strikes were pure rage. Bees swarmed frantically around the disrupted hives, thousands of them agitated by the violence that had shattered their ordered world just as it had shattered the Corwin family. Chief Corwin, a 23-year veteran of the Austin Police Department, stood frozen in his backyard, his training warring with his humanity as he looked at his wife's body. He'd seen countless crime scenes in his career, had steeled himself to view the worst humanity could offer with professional detachment. But this was Thessaly, the woman who'd supported him through the dark days after his brother's suicide, who'd built this apiary from nothing, who'd raised their 2 children while he worked impossible hours. His hands shook as he pulled out his phone to call 911, his voice breaking as he reported his own address, a location he'd driven past hundreds of times while responding to other people's tragedies. The responding officers found Chief Corwin sitting on the back porch steps, still in his uniform, his service weapons secured, but his face vacant with shock. Detective Indigo Garcia, a 9-year veteran of the department's homicide division, arrived within 18 minutes and immediately recognized the complicated dynamics of investigating a crime where the victim was married to her commanding officer. She approached Stellan with the delicate balance of colleague and investigator, gently asking him to walk her through his morning while crime scene techs began their methodical documentation. He explained he'd left for work at 6:30 a.m., attended a budget meeting that was mercifully cut short due to the city manager's illness, and returned home to find the nightmare. His alibi was ironclad, his grief apparent, but Garcia's trained instincts were already cataloging details, noting the positions of things, calculating timelines, building the framework of what would become one of Austin's most haunting cases. The Corwin children were located within the hour, their reactions offering the first hints of the fractured family dynamics that would later prove central to the case. Merritt Corwin, 20, was found at the University of Texas Library, where campus security confirmed she'd been studying since 8 p.m., her library card access records, and the surveillance footage providing absolute verification. When informed of her mother's death, Merritt's immediate response was a question that officers found odd at the time. Did she suffer? The way she asked it seemed less like concern and more like hope, a subtle inflection that Detective Garcia noted in her initial report. Merritt's relationship with Thessaly had been strained for months, ever since a confrontation about money that neighbors had overheard through the Corwins' open windows one humid September night. Breck Miller, 17, presented an entirely different scenario when investigators attempted to locate him. He'd told his father the previous evening that he'd be spending the night at his girlfriend's house in Round Rock, a suburb approximately 40 miles north of Austin. Phone records confirmed he'd been texting from that location throughout the morning, and the girlfriend's mother, Sandra Yates, verified that Breck had arrived around 9 p.m. the previous night and had been in the house all morning. When Detective Garcia and her partner drove to Round Rock to deliver the news in person, they found Breck in the Yates family living room playing video games with what appeared to be genuine relaxation. His reaction to his mother's death seemed appropriate, if somewhat muted. Tears, shock, the stammered questions of a teenage boy struggling to process sudden loss. But Detective Indigo Garcia had not risen through the ranks of Austin PD's Homicide Division by accepting surface appearances. She was 34 years old, right? The daughter of immigrants who'd taught her to notice what people didn't say, as much as what they did. As she sat across from Breck in the Yates living room, asking gentle questions about when he'd last seen his mother, she observed his body language with the intensity that had closed 31 of her 33 assigned cases. His hands were steady, his breathing regular, and there was something in his eyes that didn't quite match the tears on his face. A calculation, a watchfulness, as if he were performing grief rather than experiencing it. When he stood to use the bathroom, Garcia's eyes tracked his movements with professional precision, and that's when she saw it. On the sole of Breck's right sneaker, embedded in the tread pattern near the ball of his foot, was a single dead honeybee. The insect was small, barely noticeable, its body crushed but intact enough that Garcia could make out the distinctive fuzzy thorax and striped abdomen. In that moment, sitting in a stranger's living room 40 miles from the crime scene, Detective Indigo Garcia felt the electric jolt of instinct that every investigator lives for, the moment when seemingly random details align into pattern. Thessaly Harris had been killed in her apiary, surrounded by thousands of bees, and her son, who supposedly hadn't been home, had a bee embedded in his shoe. The odds of that being coincidental were astronomical, especially given that it was March in Texas, still too cool for bees to be common in suburban yards. Garcia maintained her composure with the discipline of her training, continuing the interview with Breck as though she'd noticed nothing unusual. She asked about his relationship with his mother, about his plans for the future, about whether he'd seen or heard anything suspicious in recent days. Breck's answers were consistent, practiced almost, painting a picture of a normal teenage boy with a normal life and a loving, if sometimes strict, mother. But Garcia was no longer listening to his words with full attention. She was watching his feet, noting how he kept them tucked under the couch, perhaps unconsciously aware of the evidence he carried. When she finally stood to leave, she asked Breck if he'd be willing to come to the station later to provide a formal statement, framing it as routine procedure for immediate family members. He agreed readily, perhaps too readily, confirming her growing suspicion that he believed himself untouchable behind his 40-mile alibi. The drive back to Austin gave Garcia time to think, to begin constructing the framework of a theory that seemed impossible, yet increasingly undeniable. If Breck had been at his mother's house that morning, he would have needed to drive 40 miles south, commit the murder, and drive 40 miles back north, all within a window that his phone records and the girlfriend's mother's testimony seemed to contradict. Yet the bee on his shoe was not the kind of evidence that appeared randomly. Carniolan bees, if that's what it was were not native to Texas and were relatively rare even among hobbyist beekeepers. Thessaly's hives were registered with the State Agriculture Department as purebred Carniolan stock, a detail Garcia had noted from the initial crime scene assessment. The probability of Breck stepping on a Carniolan bee anywhere other than his mother's property was infinitesimally small. Back at the Austin PD headquarters, Garcia immediately submitted a request for expedited forensic analysis of the bee, carefully removing it from Breck's shoe during a consensual evidence collection that she framed as routine. The crime scene techs had already collected dozens of dead bees from around Thessaly's body, and Garcia wanted comparison analysis to determine if the bee from Breck's shoe matched the genetic profile of Thessaly's hives. She also requested phone data analysis, not just the text messages Breck had sent, but the cell tower pings that would show his phone's actual physical location throughout the morning. Technology had advanced to the point where investigators could track a phone's movement with remarkable precision, and Garcia suspected that Breck's phone might tell a very different story than his alibis suggested. The bee arrived at the Texas Department of Public Safety Crime Lab in Austin on the afternoon of March 23, 2022, sealed in an evidence container that Detective Garcia had personally delivered. Dr. Helena Vasquez, a forensic entomologist with 16 years of experience, received the specimen with the kind of intense focus that Garcia recognized in fellow specialists. The two women had worked together on 4 previous cases, and Vasquez understood without being told that this tiny insect might be the linchpin of a murder investigation. She began her examination immediately, starting with visual identification under a stereo microscope that magnified the bee's body to 40 times its actual size. Within 11 minutes, she confirmed what Garcia had suspected. This was indeed a Carniolan honeybee, Apis mellifera carnica, distinguished by its grayish-brown coloring and distinctive wing venation pattern. But Dr. Vasquez's analysis went far deeper than simple species identification, employing techniques that transformed the dead insect into a witness to murder. She carefully dissected the bee's pollen baskets, the specialized structures on its hind legs, where bees collect and transport pollen back to the hive. Under high-powered magnification, she found pollen grains from 3 distinct plant species, and one of them made her pause and immediately call Detective Garcia. The pollen was from Amorphophallus titanum, commonly known as the corpse lily or Titan arum, a rare and notoriously difficult-to-grow plant known for its massive size and smell of rotting flesh. This wasn't a plant one encountered in typical Texas gardens, and, according to the county agricultural extension records that Garcia pulled within the hour, there was only one registered corpse lily in the entire Austin metropolitan area, the specimen in Thessaly Harris's garden, located approximately 15 feet from her apiary. The forensic evidence grew more damning with each passing hour of analysis. Dr. Vasquez examined the bee's body for signs of trauma and time of death, finding that the insect had been crushed with force consistent with being stepped on, not swatted, or otherwise killed. More significantly, she analyzed the bee's metabolic state and the progression of cellular breakdown, a technique that allowed her to estimate the insect had died between 2 and 3.5 hours before Garcia collected it from Breck's shoe. Given that Garcia had collected the evidence at approximately 1:30 p.m. on March 22nd, this meant the bee had died between 10:00 a.m. and noon, a window that perfectly overlapped with Thessaly's estimated time of death between 9:45 a.m. and 10:15 a.m. The 90-minute window for the bee's death, when adjusted for the metabolic rate of Carniolan bees in 68-degree weather, narrowed even further to within 90 minutes of the murder. Detective Garcia sat in Dr. Vasquez's lab office, reviewing the preliminary findings with the kind of grim satisfaction that comes from watching a theory transform into prosecutable evidence. The bee proved three critical facts. Breck had been physically present at his mother's property. He had been there during the murder window, and he had stepped on one of his mother's bees in the immediate aftermath of the killing. No alternative explanation made sense. Bees don't travel 40 miles north to Round Rock, especially not rare carniolan bees carrying pollen from an equally rare corpse lily. The evidence was circumstantial but powerful, the kind that defense attorneys struggled to explain away because it relied on biology and physics rather than eyewitness testimony or contested confessions. But Garcia knew she needed more. She needed to understand how Breck had created his alibi, how he'd made his phone appear to be in Round Rock while he was actually in Austin committing matricide. The answer came from the phone data analysis that Garcia's technical team completed on March 24, 2022, revealing a sophistication that seemed at odds with Breck's age, but perfectly aligned with his digital native generation. Breck hadn't physically taken his phone to Austin. Instead, he'd left it at the Yates house in Round Rock, where it pinged off cell towers consistently throughout the morning. But the text messages he'd sent to friends weren't typed in real time. They were scheduled messages set up the night before using a common smartphone feature that many teenagers used to seem responsive while actually sleeping or busy. The Yates family's Ring doorbell camera showed Breck leaving the house at 8:47 a.m. through the back door, a detail that Sandra Yates hadn't noticed because she'd been in her bedroom getting ready for work. He'd returned at 11:53 a.m. again through the back door. His arrival undetected because Sandra had already left for her nursing shift at 11:30 a.m. Armed with this evidence, Detective Garcia obtained a search warrant for Breck's belongings, both at the Yates house and at his father's home in Austin. The search executed on March 25, 2022, yielded evidence that transformed the case from a probable homicide to a premeditated murder with chilling ideological undertones. In Breck's backpack, hidden in a zippered compartment beneath his school books, investigators found a composition notebook containing 23 pages of a handwritten manifesto that detailed his grievances against his mother with the kind of specificity that revealed months of festering resentment. The manifesto was titled The Emasculation of Breck Miller and was written in neat print that made its violent content even more disturbing. He described Thessaly as a controlling matriarch who undermined his masculinity, questioned his judgment, and interfered with his relationship with Luna, whom he described as his soulmate, and escaped from maternal tyranny. The manifesto revealed planning that went beyond a single murder, detailing Breck's original intention to kill both his mother and his father on March 22, 2022, eliminating what he called the dual-headed monster of parental control. He'd chosen the date because it was exactly 6 months after his 17th birthday, a timeline he believed was symbolically important in establishing his independence. The plan involved waiting for his father to leave for work, killing his mother in the apiary where she worships her insects more than her family, then returning at the end of the day to kill his father and stage the scene to look like a murder-suicide. But Chief Corwin's unexpected early return had forced Breck to improvise, sparing his father's life not out of mercy, but out of tactical necessity. The manifesto's final entry, dated March 21, 2022, ended with the chilling phrase, "Tomorrow, the emasculation ends. Tomorrow, I become the master of my own destiny." Detective Garcia read the manifesto in the evidence room at Austin PD headquarters, her professional detachment cracking as she absorbed the depth of Breck's radicalization. The language and ideology were familiar to anyone who'd studied domestic terrorism and online extremism. Breck had clearly been consuming incel content, men's rights activism, taken to its most toxic extreme. He used terms like beta male subjugation and gynocentric control matrix, jargon from forums where young men convinced each other that women, particularly mothers and girlfriends, were engaged in a coordinated campaign to destroy masculine identity. Thessaly Sin, in Breck's twisted worldview, was being a successful, assertive woman who set boundaries for her teenage son. She'd committed the unforgivable act of discovering his relationship with Luna and threatening to expose it, not understanding that she was actually protecting him from a police sting operation targeting online predators. The revelation of Luna's true identity added another layer of tragedy to an already devastating case. Detective Garcia had been running the undercover operation for 7 months as part of a regional task force targeting adults who groomed minors online. She'd created the Luna persona as a 24-year-old woman seeking younger men, a profile designed to attract and document predatory behavior. Breck had made contact in August 2021 through an encrypted chat app, lying about his age and claiming to be 19. For months, Luna had engaged in progressively intimate conversations, carefully documenting everything for eventual prosecution. The operation was designed to catch the adults who initiated contact with minors, but Breck had initiated contact with Luna, complicating the legal landscape. When Thessaly discovered the conversations on Breck's laptop in early March 2022, she'd done exactly what any responsible parent would do: contacted the police to report that her son was being groomed by an adult woman. The ethical paradox was devastating. Thessaly had no way of knowing that Luna was actually a police detective running a sting operation, and Detective Garcia had no way of knowing that one of her targets was the son of her commanding officer. When Thessaly called the police on March 15, 2022, exactly 1 week before her murder, she'd spoken with a family services coordinator who'd taken her report and promised to investigate. That coordinator had routed the complaint to the appropriate division, not realizing it would intersect with an ongoing undercover operation. Garcia had received notification on March 18th that a mother had reported her son's involvement with Luna and had been instructed by task force leadership to begin winding down the operation to avoid exposure. She'd scheduled a final contact with Breck for March 30th, 2022, planning to ghost the account afterward and move on to other targets. But Thessaly, not knowing the timeline of police procedure, had told Breck on March 20th that she was going to testify about Luna and have him committed for psychological evaluation. In Breck's mind, shaped by months of radicalization in online echo chambers, Thessaly's actions represented the ultimate emasculation. She was going to expose his relationship, have him locked in a psychiatric facility, and testify in court that he was mentally unfit to make his own decisions. The manifesto revealed his belief that Luna was his ticket to freedom, that once he turned 18, he could run away with her and escape what he described as his prison of feminine control. He'd envisioned a future where he and Luna lived together, where he could finally become the man he believed his mother prevented him from being. The revelation that this was all delusion, that Luna was a police detective who viewed him as a case number rather than a soulmate, would have destroyed the entire psychological framework he'd constructed. So he'd decided to eliminate the threat before Thessaly could testify, before his delusions could be exposed, killing her among her bees with a rage that his manifesto had been building toward for months. Detective Garcia faced the difficult task of informing Police Chief Stellan Corwin that his son was not only the primary suspect in his wife's murder, but that his wife had died trying to protect that son from what she perceived as a predatory relationship. The meeting took place on March 26, 2022, in the chief's home office, a room lined with commendations and photographs from 23 years of service. Garcia watched as Corwin's face transformed from confusion to horror to a kind of broken understanding as she walked him through the evidence: the bee, the phone data, the manifesto, the connection to the Luna operation. Corwin aged a decade in the 45 minutes it took Garcia to lay out the case, his hands gripping the arms of his desk chair with enough force to turn his knuckles white. When she finished, he asked only one question, his voice barely above a whisper. Did he really plan to kill me too? Garcia confirmed that yes. According to the manifesto, Breck's original plan had included killing his father and staging a murder-suicide, but Chief Corwin's unexpected early return had forced him to improvise. Corwin sat in silence for nearly 3 minutes, a span of time that felt endless to Garcia, who'd delivered terrible news to families countless times, but never to a colleague, never to her commanding officer. Finally, Corwin spoke, his words heavy, with the weight of a father's realization that he'd failed to see the monster growing in his own home. He told Garcia to do her job, to treat this like any other case, to arrest Breck and build the strongest possible prosecution. Then he did something that would later become central to the trial. He told Garcia about the guns in his safe, illegal firearms that Breck had purchased through straw buyers online and stored in his father's gun safe without Corwin's knowledge. It was an act of devastating honesty, a police chief admitting to what prosecutors would later argue was criminal negligence in his own home. The forensic case against Breck Miller became an exemplar of modern investigative science, transforming a seemingly perfect alibi into an inescapable web of biological and technological evidence. Dr. Helena Vasquez's analysis of the honeybee continued beyond the initial identification, employing DNA sequencing that confirmed the insect came from Thessaly's hives with 99.7% certainty. The lab extracted DNA from the bee's thorax and compared it against samples from the 12 hives in Thessaly's apiary, finding a genetic match to hive number 8, the one located closest to where her body was discovered. This level of specificity transformed the bee from circumstantial evidence to near-certain proof of Breck's presence at the exact location of his mother's murder, eliminating any possibility that he'd encountered the bee elsewhere. The corpse lily pollen proved equally damning under Dr. Vasquez's continued examination, revealing details that painted a precise timeline of the murder. Amorphophallus titanum pollen is distinctive under microscopic analysis with a spiky, spherical structure that's unmistakable once properly identified. The sample from the bee's pollen baskets contained not just 1 or 2 grains, but 47 individual pollen grains, suggesting the bee had made multiple trips to the corpse lily on the morning of March 22, 2022. By analyzing the pollen's moisture content and the presence of certain enzymes that degrade over time, Dr. Vasquez determined the bee had collected this pollen between 9:15 a.m. and 10 a.m., a window that overlapped with Thessaly's estimated time of death. The science was intricate but ultimately simple. This bee had been alive and foraging in Thessaly's garden during the murder, and then died crushed beneath Breck's shoe within 90 minutes. The crime scene reconstruction team, led by Sergeant Paulo Mendez, used the bee evidence to build a detailed scenario of the murder that would later be presented to the jury with devastating effectiveness. They theorized that Breck had parked his car several blocks away from his family home, approaching through the green belt that ran behind the property to avoid being seen by neighbors. He'd entered the backyard through the gate in the fence, finding his mother tending to her hives, as she did every Tuesday morning. The attack had been sudden and brutal, the rock from the garden bed grabbed and used as a weapon in a frenzy that suggested both premeditation and explosive rage. During the attack or immediately after, Breck had stepped on at least one bee, perhaps many, as the insects swarmed in agitation around the disrupted hives and their dying keeper. The physical evidence from the crime scene supported this reconstruction with multiple corroborating details that the defense would struggle to explain away. Footprint analysis of the soft soil around the apiary revealed shoe prints consistent with Breck's size 10.5 sneakers, the same shoes from which Detective Garcia had collected the bee. The prints showed a distinctive wear pattern on the right heel that exactly matched Breck's gait, documented through surveillance footage from his school and other locations. More significantly, the prints were fresh, made on the morning of the murder according to moisture analysis of the soil displacement. Weathering patterns on the prints indicated they'd been made between 9:30 a.m. and 10:30 a.m., as determined by the evaporation rate of morning dew in 68-degree weather with 54% humidity. The science was precise enough to eliminate the possibility that the prints were made at any other time. Blood spatter analysis provided additional insights into the violence of the attack and Breck's proximity to his dying mother. The primary blood patterns around Thessaly's body were consistent with blunt force trauma from a rock-like object, with cast-off spatters indicating the weapon was raised and brought down at least 7 times. But there were also transfer patterns, small smears of blood found on the gate latch and on a fence post near the Greenbelt access point, suggesting the killer had touched these surfaces with blood on his hands as he fled. DNA analysis of these blood transfers confirmed they came from Thessaly, but they also revealed something else. Mixed in with the victim's blood were epithelial cells from the person who'd touched the surfaces. The DNA profile from those cells matched Breck Miller with the kind of statistical certainty that makes forensic scientists use terms like exclusion of all other individuals on Earth. The prosecution's forensic case expanded beyond the immediate physical evidence to include digital forensics that revealed the sophistication of Breck's planning. Analysis of his laptop, seized during the search warrant execution, showed extensive research into forensic science and criminal investigation techniques. Breck's browser history from January and February 2022 included searches for how long do fingerprints last, do police check shoes for evidence, cell phone tracking by police, and, disturbingly, how to kill someone quickly and quietly. He'd also researched his mother's work schedule, pulling up her shared family calendar multiple times to identify when she'd be home alone. The digital trail painted a picture of premeditation that undermined any potential defense argument of sudden passion or temporary insanity. The encrypted messaging apps on Breck's phone revealed the full extent of his relationship with Luna and the psychological framework that had motivated the murder. Detective Garcia, in her role as Luna, had saved every conversation according to the protocols of the undercover operation, creating a record of Breck's progressive radicalization and obsession. The messages showed him sharing his grievances about his mother, describing her as controlling and emasculating, using language clearly borrowed from incel forums and men's rights websites. Luna had played the role of sympathetic confidant, never encouraging violence, but asking leading questions that prompted Breck to reveal his thought processes. In a message from March 10, 2022, Breck had written, "Sometimes I think the only way I'll ever be free is if she just wasn't around anymore. Does that make me a terrible person?" It was as close to a confession of intent as the prosecution could hope for, written 12 days before he made that dark fantasy a reality. The forensic psychology evaluation of Breck, conducted by Dr. Miranda Chen at the request of the prosecution, provided insights into the mindset that had transformed a seemingly ordinary teenager into a matricidal killer. Dr. Chen, a forensic psychiatrist with 18 years of experience evaluating violent offenders, spent 12 hours interviewing Breck over the course of 4 sessions in April 2022. Her report, filed with the court on May 2nd, described Breck as demonstrating significant narcissistic traits, an external locus of control, and a profound inability to accept responsibility for his actions. He showed no genuine remorse for killing his mother, instead viewing himself as the victim of her control and the circumstances that had exposed his relationship with Luna. Dr. Chen's evaluation concluded that Breck's radicalization in online extremist spaces had provided him with a framework to justify matricide, transforming what should have been normal parental boundaries into perceived persecution worthy of violent response. The evidence from Merritt Corwin's investigation initially seemed to complicate the case, but ultimately strengthened it by demonstrating the thoroughness of the detective work. The discovery that Merritt had stolen $15,000 from Thessaly in November 2021 had briefly made her a person of interest, especially given that the theft had been discovered by Thessaly in early March, around the same time she'd learned about Breck's relationship with Luna. Financial records showed Merritt had taken the money through a series of fraudulent credit card charges, using her mother's card information to make purchases that she then resold for cash. Thessaly had confronted Merritt on March 8, 2022, demanding repayment and threatening to file a police report if Merritt didn't return the money within 30 days. For a brief period, this gave Merritt both motive and opportunity, since her alibi at the university library didn't begin until 8:20 a.m., leaving a potential window for her to have committed the murder before heading to campus. But the same forensic techniques that had implicated Breck ultimately exonerated Merritt, demonstrating the power of scientific evidence to eliminate suspects as effectively as it identifies them. The shoe print analysis that matched Breck's distinctive gait showed no prints consistent with Merritt's size 7 shoes anywhere near the apiary. The blood-transferred DNA on the gate and fence post contained no genetic material from Merritt. Most significantly, the bee from Breck's shoe and the corpse lily pollen timeline created a scenario that only Breck could have fulfilled, being present in the apiary during the exact window when Thessaly was killed. Merritt's theft had created family tension that likely contributed to the household stress, but she'd had no involvement in the actual murder. The false suspect trail her actions created was a coincidence that had briefly complicated the investigation, but ultimately made the case against Breck even stronger by demonstrating that investigators had thoroughly examined and eliminated alternative theories. The scientific evidence compiled by Detective Garcia and her team filled 847 pages of reports, photographs, and analysis that transformed a dead honeybee into an irrefutable timeline of murder. The prosecution had biological evidence, digital evidence, physical evidence, and psychological evidence, all pointing toward the same conclusion. Breck Miller had driven from Round Rock to Austin on the morning of March 22, 2022, leaving his phone behind to create an alibi, and murdered his mother in her backyard apiary with premeditation and extraordinary brutality. The defense would have no credible way to explain away the bee, no alternative narrative that could account for how a Carniolan honeybee carrying corpse lily pollen from Thessaly's garden ended up crushed beneath Breck's shoe within 90 minutes of the murder, while he was supposedly 40 miles away. The science had done what eyewitnesses could not. It had placed Breck at the scene of the crime with the kind of certainty that makes juries comfortable convicting. The arrest of Breck Miller took place on March 28, 2022, at the Yates family home in Round Rock, where he'd continued staying in the days following his mother's funeral. Detective Garcia led a team of 4 officers to execute the arrest warrant, timing their arrival for 6:45 a.m. to catch Breck before he was fully awake and potentially reactive. The team found him in the guest bedroom, still in his sleep clothes, his reaction to seeing uniformed officers a mixture of confusion and dawning recognition. Garcia read him his Miranda rights with the careful precision she'd learned over 9 years of investigations. Watching his face as she explained he was being charged with first-degree murder in the death of Thessaly Harris. Breck's immediate response was not denial, but a question that would later be played for the jury. How did you know? It was an admission wrapped in curiosity, the words of someone who'd believed himself clever enough to evade detection. The interrogation that followed Breck's arrest became one of the most psychologically revealing pieces of evidence in the prosecution's case. Conducted at Austin PD headquarters with Breck's court-appointed attorney present, the 3-hour session was recorded on video that captured not just words but body language, micro-expressions, and the gradual dissolution of Breck's carefully constructed facade. Detective Garcia led the interrogation with the skill that had made her one of the department's most effective investigators, starting with softball questions about Breck's relationship with his mother before gradually tightening the focus to the morning of March 22nd. She presented the evidence methodically: the bee, the pollen analysis, the phone data, the footprints, the DNA. With each revelation, Breck's confidence eroded, his shoulders slumping, as he realized the alibi he'd thought was perfect had been dismantled by science he hadn't anticipated. But it was the revelation about Luna that truly shattered Breck's composure, creating a moment of psychological collapse that the courtroom would later watch with a mixture of horror and fascination. Detective Garcia had waited until 2 hours into the interrogation to reveal her dual identity, allowing Breck to exhaust his denials and half-truths before delivering the devastating truth. She leaned forward across the interview table and said, in the same voice she'd used during months of online chats, "Breck, I need you to understand something. I am Luna. There is no 24-year-old woman who loves you. There never was. I'm a police detective, and you were part of an undercover operation targeting online predators." The video captured Breck's face, transforming from confusion to disbelief to a kind of existential horror as he processed the information. His entire psychological framework, the delusion that had motivated him to kill his mother, revealed itself as an elaborate law enforcement sting. Breck's reaction to this revelation provided prosecutors with powerful evidence of his motive and mental state. He didn't express remorse for killing his mother or horror at what he'd done. Instead, he became enraged at Detective Garcia, calling her manipulative and accusing her of entrapment, using the language of victimhood that his online radicalization had taught him. He claimed Garcia had psychologically tortured him by posing as Luna, that she'd forced him into a situation where killing his mother seemed like the only option to preserve his relationship. His attorney attempted to intervene, advising Breck to stop talking, but Breck was too far into his emotional spiral to exercise restraint. For 17 minutes, the video shows him ranting about female manipulation, maternal control, and the unfairness of a system designed to emasculate young men. It was the manifesto brought to life, the toxic ideology that had driven him to murder, now fully visible in his own words. The legal proceedings moved forward with the efficiency that characterizes strong evidence cases. The grand jury indictment came down on April 15, 2022, charging Breck with first-degree murder, abuse of a corpse for his attempts to disturb the crime scene, and obstruction of justice for the elaborate alibi he'd constructed. The prosecution, led by Assistant District Attorney Audrey Torres, a veteran prosecutor with 22 years of experience and a 87% conviction rate in murder trials, began building the case that would ultimately seek the death penalty. Torres, 49 years old and known for her methodical presentation style, recognized the Breck Miller case as both legally strong and morally complex, a teenage killer with clear premeditation, but also clear evidence of radicalization in online spaces that many jurors wouldn't fully understand. The defense team, led by public defender Marcus Shaw, faced the nearly impossible task of defending a client against overwhelming scientific evidence and his own recorded confessions. Shaw, a 15-year veteran of criminal defense who'd won acquittals in 11 murder cases, understood that traditional defense strategies wouldn't work here. The B evidence was irrefutable, the DNA analysis conclusive, the digital trail damning. Instead, Shaw began constructing a defense around diminished capacity, arguing that Brecht's exposure to online extremist content had created a form of psychological coercion that impaired his ability to appreciate the wrongfulness of his actions. It was a long-shot strategy, but given the evidence, it was perhaps the only strategy available. Shaw filed motions to suppress the manifesto as the product of mental illness rather than clear intent, to exclude the interrogation video as coerced despite the presence of counsel, and to have Brecht tried as a juvenile despite being only months away from his 18th birthday. The revelation of Chief Stellan Corwin's potential criminal liability added another layer of complexity to an already difficult case. The firearms found in the chief's safe during the search of the Corwin home included 2 handguns purchased through straw buyers that Brecht had recruited online, transactions that violated multiple federal firearms laws. Brecht had stored the guns in his father's safe without permission, using the combination he'd observed his father entering over years of living in the house. But prosecutors argued that Corwin, as both a police chief and a father, had a responsibility to secure and regularly audit the contents of his gun safe. The discovery of unauthorized firearms suggested negligence at minimum, potentially criminal facilitation at worst. Prosecutor Torres made the calculation that many district attorneys face in complex cases. She needed Corwin's testimony against his son to secure a conviction and a death sentence. But she also couldn't ignore potential criminal conduct by a sitting police chief. The deal offered to Chief Corwin was brutal in its simplicity and devastating in its implications. In exchange for his full cooperation and testimony against Brecht, including details about the firearms and any conversations he'd had with his son about Thessaly, the district attorney's office would decline to prosecute him for the firearms violations. If he refused to cooperate, he would face federal charges for illegal possession of firearms acquired through straw purchases, charges that carried a potential 10-year prison sentence and the mandatory loss of his law enforcement credentials. Corwin had 48 hours to decide whether to testify against his own son or face prosecution himself. The choice represented every parent's nightmare scenario: protect your child and lose everything, or cooperate with the prosecution and live with the knowledge that your testimony helped put your son on death row. Chief Corwin's decision to cooperate came on April 28, 2022, communicated through his attorney in a brief meeting with Prosecutor Torres. He would testify truthfully about everything he knew regarding Brecht's activities, the firearms, and the family dynamics that might have contributed to Thessaly's murder. In exchange, he would receive immunity from prosecution on the firearms charges and be allowed to remain police chief pending the outcome of the trial, though he understood his career was effectively over, regardless of the legal outcome. The agreement was formalized in writing, creating a paper trail that defense attorney Shaw would later argue demonstrated the coercive nature of the state's case. But from Torres's perspective, it was necessary leverage to secure the testimony of a crucial witness who might otherwise have invoked his Fifth Amendment rights to avoid self-incrimination. The pretrial hearings throughout May and June 2022 revealed the prosecution's strategy of building toward a trial that would be as much about Brecht's ideology as his actions. Torres filed motions to admit extensive evidence of Brecht's online activities, including his participation in incel forums, his consumption of content promoting violence against women, and his manifesto detailing his grievances against his mother. Defense attorney Shaw objected strenuously, arguing this evidence was more prejudicial than probative, designed to inflame the jury against a troubled teenager rather than prove the elements of murder. Judge Kayalani Tuiasosopo, a 12-year veteran of the bench known for her careful balancing of defendants' rights with public safety, ruled that the online activity and manifesto were admissible as direct evidence of premeditation and motive. Her ruling acknowledged the prejudicial nature of the evidence, but found it essential to understanding why a 17-year-old would murder his mother with such brutality. Merritt Corwin's role in the case evolved from suspect to witness as prosecutors worked to understand the full dynamics of the family Thessaly had tried to hold together. Interviews with Merritt revealed a household marked by tension between Thessaly's high expectations and her children's resentment of what they perceived as controlling behavior. Merritt admitted the theft of $15,000 had been motivated by a desire to escape her mother's influence, using the money to secure an apartment and establish independence. She described Thessaly as impossible to please, someone who monitored grades, social activities, and future plans with an intensity that felt suffocating. But Merritt also acknowledged that her mother's strictness came from love and a desire to see her children succeed. She broke down during her interview when prosecutors asked if she'd had any indication Breck was capable of murder, sobbing that she'd noticed his increasing anger toward Thessaly, but assumed it was normal teenage rebellion. The revelation that her brother had planned to kill both parents shattered her understanding of her family, leaving her to grapple with the knowledge that she'd grown up alongside someone capable of matricide and potential parricide. The psychological evaluation of Breck, ordered by the court as part of the pretrial proceedings, provided additional insights into a mind shaped by online radicalization and narcissistic grievance. Dr. Chen's second evaluation, conducted in June 2022, specifically to assess competency to stand trial and criminal responsibility, found Breck fully understood the nature of the proceedings against him and was capable of assisting in his own defense. But her report also detailed the concerning extent of his immersion in extremist ideology, noting he spent an average of 6 hours per day in online forums where violence against women was normalized and maternal authority was framed as oppression. Breck had internalized the language of victimhood so completely that he genuinely believed he was the wronged party, that his mother's murder was a form of justified resistance against tyrannical control. Dr. Chen's clinical opinion was that while Breck suffered from narcissistic personality traits and had been exposed to radicalizing content, he did not meet the legal standard for insanity. He knew killing his mother was wrong in the eyes of society. He simply believed society was wrong to condemn him for it. The preliminary hearing on July 12, 2022, marked the first public airing of the evidence against Breck Miller, transforming what had been whispered about in Austin into documented fact presented in open court. Judge Tuiasosopo presided over the proceedings in a courtroom packed with media, community members, and law enforcement personnel who'd worked with Chief Corwin over his 23-year career. The atmosphere was heavy with the kind of tragic awareness that comes from watching a family's private nightmare become public spectacle. Prosecutor Torres presented a streamlined version of her case, focusing on the irrefutable scientific evidence that placed Breck at the murder scene during the time his mother was killed. She called Dr. Vasquez to testify about the bee and pollen analysis, her testimony delivered with the clinical precision that makes expert witnesses effective. The jury would later hear this testimony in much greater detail, but even in summary form, it was devastating. Detective Garcia's testimony at the preliminary hearing provided the emotional core of the prosecution's case, the moment when the pure science of forensic evidence combined with the human element of investigation and justice. She described the initial interview at the Yates house with matter-of-fact professionalism, explaining how she'd noticed the bee on Breck's shoe and immediately recognized its significance. But when Torres asked her to explain the Luna operation, Garcia's testimony took on a different tone, one that acknowledged the ethical complexity of her role. She explained she'd been conducting a legitimate undercover operation targeting adults who solicited minors for illegal sexual relationships. Breck had lied about his age when making contact, claiming to be 19, and the operation had been focused on documenting what investigators believed was predatory behavior by an adult. The discovery that Luna was actually being used by a teenager to fantasize about escape from parental control had been unexpected and tragic. The revelation of Garcia's dual identity in the courtroom created a moment of visible shock, even among those who'd followed the case closely in media coverage. The gallery watched as she explained, her voice steady, but her eyes betraying the personal toll of the case, how she'd maintained the Luna persona for 7 months, never encouraging violence, but asking questions designed to prompt Breck to reveal criminal intent from adults he might be in contact with. When Thessaly had called police about her son's involvement with an adult woman, Garcia had been notified, but the bureaucracy of coordinating between divisions had meant Thessaly never learned she was reporting an undercover police operation. The tragic irony was inescapable. Thessaly had died trying to protect her son from a threat that didn't exist, while the real threat was Breck himself, radicalized by online extremism into believing his mother's protective impulses were oppression worthy of murder. The defense's cross-examination of Detective Garcia focused on the ethics of the undercover operation, with Attorney Shaw attempting to establish that Garcia's interactions with Breck had amounted to psychological manipulation that contributed to his deteriorating mental state. Shaw presented chat logs showing Luna asking Breck about his relationship with his mother, his feelings of independence, his frustrations with parental control. Wasn't this, Shaw argued, a form of grooming in itself, encouraging a troubled teenager to externalize his problems and view his mother as an enemy? Garcia's response was measured but firm. She'd asked open-ended questions consistent with building rapport in undercover operations. She'd never suggested violence, never encouraged Breck to harm anyone, never done anything except allow him to reveal his own thought processes. The chat logs, when read in full rather than cherry-picked excerpts, showed Breck driving the conversations toward his grievances, not Garcia leading him there. Judge Tuiasosopo ruled at the conclusion of the preliminary hearing that sufficient evidence existed to bind Breck over for trial on all charges, a decision that surprised no one given the strength of the prosecution's case. But her comments from the bench provided a preview of how she would approach the trial itself, acknowledging the complexity of a case involving a teenage defendant, radicalized by online extremism, while also recognizing the premeditated brutality of the murder. She noted that Breck's age would be a factor in sentencing considerations, but couldn't excuse the calculated nature of his actions. The manifesto, the alibi construction, the research into forensic techniques all pointed towards someone who understood exactly what he was doing and took steps to avoid detection. The fact that a 17-year-old had been sophisticated enough to attempt such planning made the crime more disturbing, not less, suggesting a level of cognitive function that undermined any claim of diminished capacity. The formal arraignment on July 25, 2022, marked the point when Breck Miller officially entered his plea in district court. Defense attorney Shaw had counseled a not guilty plea, preserving all options for trial while leaving open the possibility of a negotiated plea if the prosecution proved willing to remove the death penalty from consideration. Breck stood before Judge Tuiasosopo in an orange jail jumpsuit. His appearance markedly changed from the clean-cut teenager who'd been arrested 4 months earlier. He'd lost approximately 20 pounds in county jail, his face gaunt, and his eyes carrying the hollow look of someone beginning to understand the consequences of his actions. When asked how he pleaded to the charge of first-degree murder, Breck spoke in a voice barely above a whisper, "Not guilty." The two words hung in the courtroom, a formality everyone knew was technically correct, but morally complicated, given the evidence against him. The prosecution's decision to seek the death penalty against a defendant who was 17 at the time of the murder created significant legal and ethical debates within the district attorney's office and the broader community. Texas law allowed for the death penalty for crimes committed at age 17, one of only a handful of states that maintained this provision. Prosecutor Torres had consulted with the victim's family, with law enforcement leadership, and with her own conscience before making the recommendation to her boss, District Attorney Helen Pritchard. The manifesto had been the deciding factor. Breck hadn't killed in a moment of passion or temporary insanity. He'd planned the murder for months, researched techniques to avoid detection, and shown no remorse when caught. The death penalty, Torres argued, was appropriate for someone who'd demonstrated such calculated evil regardless of age. Chief Corwin, when consulted as the victim's husband, had supported the death penalty recommendation, a decision that clearly caused him immense pain, but which he felt honored Thessaly's memory. The defense's motion to exclude the death penalty based on Breck's age at the time of the offense was denied by Judge Tuya Sosapo on August 8, 2022, in a ruling that cited Texas statute and Supreme Court precedent allowing capital punishment for 17-year-old offenders. Shaw had argued that evolving standards of decency and recent neurological research about adolescent brain development should preclude executing someone for crimes committed before age 18. Judge Tuya Sosapo acknowledged the research but found that Texas law was clear and that Breck's sophisticated planning demonstrated cognitive maturity that undermined arguments about adolescent impulsivity. The ruling meant the trial would proceed as a capital case, with the jury making two separate determinations, guilt or innocence, and if guilty, life in prison or death by lethal injection. The stakes couldn't have been higher for a defendant who wouldn't turn 18 until September 2022, a birthday he would spend in county jail awaiting trial. The victim impact statements collected by the prosecution during the pretrial phase painted a portrait of Thessaly Harris that contrasted sharply with Breck's characterization of her as a controlling tyrant. Colleagues from the forensic accounting firm where she'd worked for 11 years described her as brilliant, dedicated, and passionate about using financial analysis to support criminal investigations. She'd helped solve embezzlement cases, money laundering schemes, and fraud operations, her work directly contributing to 23 criminal convictions over her career. Friends described a woman who was deeply involved in her community, who taught free financial literacy classes at the local library, who donated honey from her apiary to food banks. Her passion for beekeeping had started as a stress relief hobby, but evolved into a serious avocation, her Carniolan hives producing award-winning honey that she shared generously. The woman her friends and colleagues knew bore little resemblance to the oppressive figure Breck had described in his manifesto. Chief Corwin's victim impact statement, submitted in writing because he couldn't speak it aloud without breaking down, was perhaps the most devastating document in the entire case file. He described 22 years of marriage to a woman who'd supported him through the darkest periods of his career, who'd raised their children to be thoughtful and ambitious, who'd created a home filled with love despite his demanding job. He acknowledged that Thessaly had been strict with the children, that she'd set high expectations and enforced consequences when those expectations weren't met. But he also noted that this strictness came from a place of profound love and a desire to see Breck and Merritt succeed in a world that she knew could be unforgiving. The revelation that Breck had viewed this love as oppression worthy of murder had shattered Corwin's understanding of his own family. He wrote that he would never forgive himself for not seeing the warning signs, for not recognizing that his son was being radicalized by online extremism, for not protecting his wife from the ultimate betrayal. The trial date was set for October 17, 2022, giving both sides 3 months to prepare for what everyone involved recognized would be one of the most significant criminal trials in Austin's recent history. The case had everything that captured public attention. A police chief's family destroyed from within, cutting-edge forensic science, solving a seemingly perfect crime, online radicalization leading to real-world violence, and the specter of the death penalty for a teenage defendant. Media coverage was extensive and mostly sympathetic to the prosecution, with local news outlets running features on Thessaly's life and work, alongside explainers about incel ideology and online extremism. Defense attorney Shaw gave few interviews, recognizing that his client's manifesto and recorded confession left little room for favorable public opinion. The best he could hope for was a jury that would see Breck as a troubled teenager who'd been manipulated by online predators rather than as a calculating killer who deserved the ultimate punishment. The trial of Breck Miller began on October 17, 2022, in the 299th District Court of Travis County, with Judge Keilani Tuiasosopo presiding over a courtroom that had been modified to accommodate the intense media interest and security concerns. The jury selection had taken 3 days, winnowing a pool of 180 potential jurors down to 12 members and 4 alternates who'd convinced both sides they could be fair despite the extensive pre-trial publicity. The final jury consisted of 7 women and 5 men, ranging in age from 24 to 67, representing a cross-section of Austin's diverse population. Prosecutor Torres had looked for jurors who could handle scientific evidence and wouldn't be swayed by sympathy for a teenage defendant, while defense attorney Shaw had sought jurors who might be troubled by executing someone for crimes committed at age 17. The composition suggested both sides had partially achieved their goals, setting up what promised to be a hard-fought battle over Breck's fate. Prosecutor Torres's opening statement lasted 47 minutes and laid out a narrative of betrayal, radicalization, and calculated murder that held the courtroom in rapt attention. She began not with the murder itself, but with Thessaly Harris's life, describing a woman who'd built a career helping law enforcement solve complex financial crimes, who'd raised bees as a form of meditation and connection to nature, who'd loved her children fiercely, even when they made that love difficult. Torres showed the jury photographs of Thessaly in her apiary, tending her hives with the care and attention she brought to everything she did. Only after establishing Thessaly as a full, complex human being did Torres pivot to describe how her own son had murdered her with 7 blows from a garden rock, driven by an ideology absorbed from online forums that taught him to view his mother's love as oppression. The jury's faces reflected shock and revulsion as Torres detailed the planning, the manifesto, the constructed alibi, and the arrogance with which Breck had believed he'd gotten away with murder. The prosecution's case unfolded over 8 days of testimony that methodically built an unassailable scientific foundation for Breck's guilt. Dr. Vasquez testified for nearly 6 hours across 2 days, explaining the bee and pollen evidence with a combination of scientific rigor and accessible language that helped the jury understand how a single insect could serve as such powerful proof. She brought enlarged photographs of the bees' pollen baskets showing the distinctive corpse lily pollen grains under microscopic magnification. She explained the DNA sequencing process that matched the bee to Thessaly's hive number 8 with 99.7% certainty. Most powerfully, she walked the jury through the timeline analysis, demonstrating how the bee's death within 90 minutes of being crushed combined with its collection of pollen during the murder window created a scientific alibi buster that Breck couldn't explain away. Defense attorney Shaw's cross-examination focused on the margin of error in the time-of-death estimates for both the bee and Thessaly, but the margins were so narrow that even accounting for uncertainty, Breck had been present at the murder scene during the critical period. Detective Garcia's testimony spanned 3 full days and represented the emotional heart of the prosecution's case. She walked the jury through the investigation from her initial arrival at the crime scene through the final arrest, explaining each step of the detective work that had built the case against Breck. Her description of spotting the bee on Breck's shoe during the interview at the Yates house had the quality of a detective novel, the moment when a trained observer noticed what others would miss. But it was her testimony about the Luna operation that created the most dramatic moment of the trial. Torres had her explain the undercover work in detail, how she'd created the persona, how Breck had initiated contact, how she'd documented conversations designed to identify adults soliciting minors. When Torres asked Garcia to reveal herself as Luna to the jury, just as she'd done to Breck during the interrogation, the courtroom fell into absolute silence. The video of Breck's interrogation played on screens throughout the courtroom, 3 hours of recording edited down to 47 minutes of the most incriminating segments. The jury watched Breck's reactions to each piece of evidence presented by Detective Garcia, his confidence eroding as he realized the alibi he'd constructed was being systematically demolished. They saw his face change from confusion to horror when Garcia revealed herself as Luna, the moment his entire psychological framework collapsed. Most damningly, they watched his 17-minute rant about female manipulation and maternal oppression, his complete failure to express remorse or acknowledge wrongdoing, his narcissistic insistence that he was the victim of circumstances rather than a murderer who'd taken his mother's life. Defense attorney Shaw had fought hard to exclude this video, arguing it was more prejudicial than probative, but Judge Tuiasosopo had ruled it admissible as direct evidence of Breck's motive and mental state. Watching it, several jurors shook their heads in disbelief at the defendant's complete lack of empathy. The forensic evidence continued with testimony from the crime scene reconstruction team, the DNA analysts, the digital forensics experts who'd traced Breck's online activities and uncovered his research into forensic investigation techniques. Each witness added another piece to the prosecution's mosaic, creating a picture of premeditated murder so complete that defense attorney Shaw's cross-examinations could barely dent it. The shoe print analysis matched Breck's distinctive gait. The blood transfer DNA placed his cells, mixed with his mother's blood, on the gate he'd used to flee the scene. The phone data showed the sophisticated alibi construction that proved planning rather than impulse. The browser history revealed months of research into how to kill someone and avoid detection. Every piece of evidence pointed the same direction, toward the conclusion that Breck Miller had murdered his mother with calculation and tried to escape justice through careful planning that ultimately failed because he'd stepped on a bee. Chief Stellan Corwin's testimony on the 7th day of trial represented one of the most painful spectacles in Austin's judicial history. He took the stand dressed in civilian clothes, having resigned as police chief, effective October 1st, under pressure from the mayor's office and community groups who argued he'd failed in his fundamental responsibility to secure weapons in his home. Torres questioned him gently but thoroughly, establishing the firearms in his safe that belonged to Breck, the conversations he'd had with his wife about their son's increasingly troubling behavior, and the manifesto's revelation that Breck had planned to kill him along with Thessaly. Corwin's voice broke multiple times as he testified, particularly when Torres asked him to describe finding Thessaly's body in the apiary. He described the moment as the end of the world I knew, explaining that everything after, the investigation, the arrest, the trial, felt like moving through a nightmare from which he couldn't wake. Defense attorney Shaw's cross-examination of Chief Corwin was aggressive, attempting to establish that the prosecution had coerced his testimony by threatening firearms charges. Shaw presented the immunity agreement, questioning whether Corwin's testimony was truly voluntary when given under threat of a 10-year prison sentence, but Corwin's response undercut the defense strategy. He stated clearly that while the immunity agreement had influenced his decision to cooperate, his testimony was truthful, regardless of the circumstances that prompted it. Everything he'd said on the stand was accurate to the best of his knowledge. Yes, the prosecutors had leverage over him through the firearms charges, but that leverage had simply forced him to do what he should have done from the beginning: tell the complete truth about his son's crimes and his own failures as a father to recognize the warning signs. Shaw's attempt to discredit Corwin as a coerced witness largely backfired, instead highlighting the tragedy of a father forced to testify against his son to avoid prosecution himself. The most dramatic moment of Chief Corwin's testimony came when Prosecutor Torres asked him to read a passage from Breck's manifesto, the section describing the original plan to murder both parents. Corwin's hands trembled as he held the photocopied pages, his voice barely audible as he read his son's words. "The old man will be harder to kill than the matriarch. He's trained, armed, and paranoid. But he's also predictable. He comes home at 6 p.m. every Tuesday and Thursday. He parks in the garage, enters through the kitchen, and goes directly to his study to check emails. He won't see it coming. Neither of them will see it coming. And when it's done, when both sources of my oppression are eliminated, I'll be free to start my life with Luna." The courtroom sat in stunned silence as Corwin finished reading, tears streaming down his face. He looked directly at Breck for the first time during his testimony and said, "I failed you as a father. I should have seen this. But what you did to your mother is unforgivable." Breck's response was a smirk, a slight upturn of his lips that was caught by the courtroom cameras and would be replayed endlessly in media coverage. The prosecution rested its case on October 28, 2022, after calling 31 witnesses and presenting 847 pages of documentary evidence. Torres's final witness was Dr. Chen, the forensic psychiatrist, who'd evaluated Breck and found him competent to stand trial and criminally responsible for his actions. Dr. Chen testified that while Breck showed signs of narcissistic personality traits and had been exposed to radicalizing online content, he fully understood the wrongfulness of killing his mother and had made a conscious choice to do so anyway. His planning, his alibi construction, and his attempts to conceal evidence all demonstrated cognitive function inconsistent with legal insanity or diminished capacity. The defense's cross-examination attempted to establish that online radicalization created a form of brainwashing that impaired Breck's judgment, but Dr. Chen countered that exposure to extremist ideology doesn't eliminate free will or moral responsibility. Breck had chosen to embrace the ideology that justified matricide. He hadn't been forced into it against his will. Defense attorney Marcus Shaw's opening of the defense case on October 31, 2022, represented an acknowledgement of the impossible position his client was in. Shaw didn't dispute the scientific evidence placing Breck at the crime scene, or even that Breck had killed his mother. Instead, he framed his defense around the question of moral culpability, arguing that a 17-year-old exposed to sophisticated online propaganda designed to radicalize vulnerable young men couldn't be held to the same standard of responsibility as an adult. Shaw described Breck as a victim himself, a teenager groomed by anonymous online extremists into believing his mother's normal parental boundaries constituted oppression worthy of violent resistance. The argument required the jury to hold two contradictory ideas simultaneously: that Breck was sophisticated enough to plan and execute a murder, but not mature enough to be fully responsible for choosing to do so. It was a difficult sell, particularly given the evidence of Breck's careful planning and complete lack of remorse. The defense's expert witness testimony focused on adolescent brain development and the psychology of online radicalization. Dr. Robert Kensington, a neuropsychologist from the University of Texas, testified about the prefrontal cortex's incomplete development in teenagers, explaining that the region responsible for impulse control and long-term consequence assessment doesn't fully mature until the mid-20s. He presented fMRI studies showing different activation patterns in teenage brains compared to adult brains when processing risk and reward. While this testimony was scientifically sound, Prosecutor Torres's cross-examination highlighted the difficulty in applying general developmental psychology to specific criminal behavior. She asked Dr. Kensington whether the same incomplete brain development that might lead a teenager to shoplift or drive recklessly could also explain months of murder planning, manifesto writing, and sophisticated alibi construction. Dr. Kensington acknowledged that Breck's level of planning was unusual for a teenager and didn't fit typical patterns of adolescent impulsivity. The defense's second expert, Dr. Angela Morrison, specialized in online radicalization and testified about the sophisticated techniques used by extremist communities to recruit and indoctrinate vulnerable individuals. She explained how incel forums use a combination of love-bombing new members, gradually introducing extreme ideology, and creating echo chambers where dissenting views are eliminated. Dr. Morrison argued that Breck had been exposed to this process over approximately 18 months, beginning in early 2021 when he first discovered men's rights forums, and progressing to increasingly extreme spaces that normalized violence against women. Her testimony included examples of posts from the forums Breck frequented, messages that framed maternal authority as emasculation, and suggested that true men wouldn't tolerate female control. The implication was that Breck had been psychologically conditioned to view his mother as an enemy and violence as a legitimate response. Prosecutor Torres's cross-examination of Dr. Morrison focused on personal responsibility and the millions of young men who view similar content without committing murder. Torres presented data showing that incel forums had hundreds of thousands of users, yet the number who committed violence was statistically tiny. She asked Dr. Morrison whether exposure to extremist content eliminated free will or simply provided ideological justification for violence that some individuals were already predisposed toward. Dr. Price Morrison acknowledged that most individuals exposed to radical content don't commit violence, but argued that Breck's particular combination of narcissistic traits, family tension, and exposure to extremist ideology created a perfect storm of risk factors. Torres's response was pointed. Perfect storms of risk factors don't eliminate criminal responsibility. They explain motive while confirming the defendant's capacity to choose differently. The defense called Merritt Corwin as a witness on November 7, 2022, attempting to establish a pattern of maternal control that might contextualize Breck's grievances. Merritt testified reluctantly, clearly uncomfortable with being used to support her brother's defense after he'd murdered their mother. She acknowledged that Thessaly had been demanding that she'd set high expectations and enforced strict rules about grades, social activities, and future planning. Merritt described feeling suffocated at times by her mother's constant monitoring and correction. But when defense attorney Shaw asked if she'd ever felt emasculated or oppressed by their mother, Merritt's response devastated the defense strategy. She said that while she'd sometimes resented her mother's strictness, she'd never felt anything approaching the hatred Breck described in his manifesto. Looking directly at the jury, Merritt said, "My mother could be difficult, but she loved us. What Breck did wasn't a response to her parenting. It was murder, and I'll never forgive him for taking her from us." Breck Miller's decision to testify in his own defense against the strong advice of his attorney became the defining moment of the trial. Shaw had argued strenuously that nothing good could come from putting Breck on the stand, that his narcissistic personality traits and inability to express genuine remorse would alienate the jury, but Breck insisted he needed to tell his story, apparently believing he could convince the jury to see him as a victim of circumstances rather than a calculating murderer. He took the stand on November 9, 2022, dressed in a suit provided by his attorney, his appearance cleaned up, but his demeanor suggesting the same arrogance that had characterized his interrogation video. For 2 hours of direct examination, Shaw guided Breck through his version of events, attempting to frame the murder as a tragic outcome of online radicalization and psychological manipulation by the Luna operation. Breck's testimony on direct examination followed the script Shaw had prepared, describing a lonely teenager who'd found community and validation in online forums after feeling rejected by his peers and controlled by his mother. He claimed the Luna relationship had given him hope for a different future, a life where he could make his own choices and be appreciated for who he was. When his mother discovered the relationship and threatened to have him committed and testify against Luna, he said he'd felt trapped with no way out. The murder, in his telling, was a desperate act by someone who couldn't see alternatives, not the calculated matricide the prosecution portrayed. He cried several times during this testimony, his emotion appearing genuine enough that some observers wondered if the jury might feel sympathy. That illusion was shattered when Prosecutor Torres began her cross-examination. Torres's cross-examination of Breck Miller lasted nearly 4 hours across 2 days and systematically destroyed any sympathy the jury might have developed during his direct testimony. She began by reading passages from his manifesto, asking him to explain specific phrases like, "The emasculation ends tomorrow, and both sources of my oppression will be eliminated." Breck attempted to contextualize these phrases as the writings of someone in psychological distress, not actual plans for murder. But Torres then presented the browser history showing his research into forensic techniques, his searches for how to kill someone quickly, and his review of his mother's calendar to identify when she'd be home alone. She asked Breck to explain how these searches aligned with his claim that the murder was impulsive rather than planned. His answers became increasingly defensive and contradictory, his arrogance showing through as he argued with Torres about the interpretation of evidence. The devastating moment came when Torres asked Breck about his reaction to learning that Luna was Detective Garcia conducting an undercover operation. She played the interrogation video showing his rant about female manipulation and entrapment, then asked him if he'd expressed any remorse for killing his mother during that 17-minute outburst. Breck tried to explain that he'd been in shock, that his reaction to the Luna revelation had temporarily overwhelmed his grief about his mother. Torres then asked a simple question that hung in the courtroom silence. "Mr. Miller, in the 8 months since you killed your mother, have you ever expressed genuine remorse for taking her life? Not regret about being caught, not anger about the consequences, but actual sorrow for what you did to a woman who loved you?" Breck's response after a long pause was telling, "I regret that things turned out this way." It wasn't an expression of remorse. It was a passive construction that avoided taking responsibility. The jury's faces showed they'd noticed. The cross-examination's final sequence focused on the manifesto's revelation that Breck had planned to kill his father along with his mother. Torres asked Breck to explain why, if he was truly acting in desperate self-defense against maternal oppression, he'd also planned to murder his father, who he'd described as relatively uninvolved in his life. Breck's answer revealed the narcissism that had driven his actions. He said his father enabled his mother's control and therefore deserved the same fate. Torres then asked why he'd smiled when his father testified about reading the manifesto passage describing plans to kill him. Breck claimed he hadn't smiled, that Torres was misinterpreting his facial expression. Torres played the courtroom video showing Breck's clear smirk during that testimony. His attempt to deny what the video plainly showed demonstrated either dishonesty or a complete lack of self-awareness. Either way, it destroyed his credibility with the jury. The defense rested on November 14, 2022, after calling just 7 witnesses compared to the prosecution's 31. Shaw had presented the best case possible given the evidence, but it was clear from the courtroom atmosphere that the scientific proof of Breck's guilt and his own testimony had undermined any chance of acquittal. The question now was not whether he'd be convicted, but what sentence he'd receive. Shaw had focused much of his closing argument on the sentencing phase, previewing his plea for the jury to spare Breck's life based on his youth and the possibility of rehabilitation. But even that argument seemed weakened by Breck's complete failure to demonstrate remorse or growth during his time in custody. A defendant seeking mercy typically shows some evolution in understanding, some acknowledgement of wrongdoing. Breck had shown none of that, instead maintaining his position as a victim of circumstances even when confronted with overwhelming evidence of his calculated planning and execution of his mother's murder. Prosecutor Audrey Torres's closing argument on November 15, 2022, synthesized 8 days of prosecution testimony and nearly 900 pages of evidence into a narrative of betrayal, calculation, and justice. She began by returning to Thessaly Harris, reminding the jury of the woman whose life had been brutally ended by her own son. Torres showed photographs of Thessaly in her apiary, at work helping solve financial crimes, teaching beekeeping workshops at the community center. She described a woman who dedicated her life to service, both through her forensic accounting work and her volunteer efforts in the Austin community. Then Torres contrasted this life of contribution with the senseless violence that ended it, describing how Thessaly's final moments in her beloved apiary must have been filled with terror and betrayal as her son struck her 7 times with enough force to fracture her skull in 3 places. The jury sat in rapt attention, several members wiping tears as Torres painted the picture of Thessaly's final moments. Torres then systematically reviewed the evidence, starting with the honeybee that had been the breakthrough in the case. She reminded the jury of Dr. Vasquez's testimony about the carnelian species match, the corpse lily pollen found nowhere else in Austin, and the 90-minute window for the bee's death that overlapped perfectly with Thessaly's murder. She walked through the shoe print evidence, the DNA analysis, the phone data showing the sophisticated alibi construction. Each piece of evidence was presented not in isolation, but as part of an interconnected web that left no reasonable doubt about Breck's guilt. Torres emphasized that this wasn't a case requiring the jury to weigh conflicting eyewitness testimony or questionable circumstantial evidence. This was a case where biology, physics, and digital forensics all pointed to the same conclusion. Breck Miller murdered his mother with premeditation and tried to escape justice through careful planning that ultimately failed. The prosecution's closing argument reached its emotional peak when Torres addressed the manifesto and Breck's testimony. She read key passages from the manifesto, asking the jury to hear Breck's own words describing his mother as an oppressor who deserved elimination. She reminded them of the browser history showing months of research into murder and forensic avoidance. She replayed segments of the interrogation video showing Breck's complete lack of remorse and his narcissistic insistence on victimhood, and she highlighted his testimony, particularly his smirk when his father read the manifesto passage about plans to kill him, and his inability to express genuine remorse even when directly asked. Torres argued that this wasn't a troubled teenager who made a tragic mistake. This was a calculating individual who planned and executed matricide then showed contempt for the court, the jury, and the memory of his victim when called to account. Torres concluded her closing argument with a direct appeal to the jury's sense of justice and moral responsibility. She acknowledged that convicting a teenager of first-degree murder and potentially sentencing him to death was an enormously difficult decision that would weigh on them for the rest of their lives. But she argued that the evidence demanded nothing less than conviction on all charges. Breck Miller had murdered his mother with premeditation and calculation. He'd shown no remorse, no growth, no indication that he understood the magnitude of what he'd done. The law existed to hold people accountable for their choices. And Breck had made the choice to end his mother's life, despite having every opportunity to make different choices. Torres ended with a direct statement to the jury. Thessaly Harris cannot speak for herself anymore. Her voice was silenced forever by 7 blows from a rock wielded by the son she loved. Your verdict is the only voice she has left. Let it speak clearly. Breck Miller is guilty of first-degree murder, and he must be held accountable. Defense attorney Marcus Shaw's closing argument began on the afternoon of November 15th, lasting approximately 2 hours as he made his final appeal to the jury. Shaw acknowledged the strength of the prosecution's evidence, conceding that Breck had killed his mother and that the scientific proof of his presence at the crime scene was irrefutable. But he urged the jury to consider the context of those actions, the sophisticated online radicalization that had warped a vulnerable teenager's perception of reality. Shaw described the incel forums as a form of psychological warfare, systematically breaking down Breck's normal moral framework and replacing it with an ideology that normalized violence against women. He argued that while Breck was legally responsible for his actions, the jury should consider his youth and the manipulation he'd experienced when determining his level of moral culpability. Shaw's most effective argument centered on the question of whether executing a 17-year-old served justice or simply perpetuated tragedy. He reminded the jury that Breck's brain was still developing, that neurological research showed the prefrontal cortex wouldn't fully mature for another 7 years. He argued that life in prison would serve the interests of justice and public safety, while acknowledging the possibility, however remote, of rehabilitation over decades of incarceration. Execution, Shaw contended, was a permanent solution that foreclosed any possibility of growth or change. He asked the jury to consider whether Breck at age 40 or 50, after years of maturation and reflection, might evolve into someone who genuinely understood and regretted what he'd done at age 17. Killing him through lethal injection eliminated that possibility, making society complicit in ending a life just as Breck had ended his mother's. But Shaw's closing argument struggled to overcome the damage Breck had done through his own testimony and the manifesto's chilling revelations. Shaw tried to contextualize Breck's lack of remorse as a product of his narcissistic personality traits and continued immersion in the distorted worldview that had motivated the murder. He argued that Breck's inability to express genuine sorrow was itself evidence of the psychological damage wrought by online radicalization, not proof that he was beyond redemption. But this argument required the jury to extend sympathy to a defendant who'd shown none to his victim, who'd smirked while his father testified about plans to murder him, who'd cried only when discussing the consequences to himself rather than the life he'd taken. The jury's body language suggested Shaw's arguments, while articulately presented, weren't resonating with people who'd watched Breck's testimony and seen no evidence of the vulnerable teenager Shaw described. Shaw concluded his closing argument with a plea for mercy that acknowledged the enormity of what Breck had done while asking the jury to resist the impulse toward vengeance. He reminded them that the decision they made would define not just Breck's fate, but also their own moral standing. Execution, Shaw argued, reduced the jury to Breck's level, responding to killing with more killing, in a cycle that dishonored Thessaly's memory rather than served it. he asked them to choose life in prison, a sentence that would ensure Breck never walked free while preserving the possibility, however slim, that he might one day evolve into someone capable of genuine remorse and understanding. It was a powerful conclusion to a difficult argument, but the jury's faces suggested they'd already made their decision about guilt, even if the sentencing question remained open. The jury deliberations began at 3:47 p.m. on November 15, 2022, after Judge Tuiasosopo provided detailed instructions on the law governing first-degree murder, the standards for considering evidence, and the requirement for unanimous verdicts. The jury deliberated for 4 hours and 23 minutes on the first day before being sequestered for the night, resuming deliberations at 9 a.m. on November 16th. The relatively short deliberation time suggested the strength of the prosecution's evidence, though observers noted the jury had requested to review several pieces of evidence, including the interrogation video and portions of the manifesto. The request suggested they were being thorough, examining the evidence carefully despite the seemingly overwhelming case for guilt. At 2:34 p.m. on November 16th, after a total of 9 hours and 11 minutes of deliberation, the jury informed the bailiff they'd reached a verdict. The courtroom was packed when Judge Tuiasosopo reconvened court at 3 p.m. to receive the verdict. Chief Corwin sat in the gallery, his face drawn and aged beyond his 51 years, flanked by Merritt and several of Thessaly's relatives who'd traveled from out of state for the trial. Breck sat at the defense table in his suit, his expression unreadable as the jury filed in and took their seats. The foreperson, a 52-year-old high school teacher named Patricia Nguyen, stood when Judge Tuiasosopo asked if the jury had reached a verdict. She confirmed they had reached unanimous decisions on all charges. The courtroom fell into absolute silence as the clerk accepted the verdict form and prepared to read it aloud. The moment stretched out with the painful tension of consequences about to become reality. A teenage boy's life hanging in the balance of words about to be spoken. We, the jury, find the defendant Breck Miller guilty of murder in the first degree, the clerk read, her voice steady and clear. The words landed like a physical blow, Chief Corwin's shoulders shaking with silent sobs, while Thessaly's mother cried openly in the gallery. Breck's reaction was minimal, a slight tensing of his jaw, but no tears, no visible emotion beyond a kind of resignation. The clerk continued reading the verdicts on the additional charges: guilty of abuse of a corpse for his attempts to disturb the crime scene, guilty of obstruction of justice for the alibi construction. On each charge, the verdict was unanimous and unequivocal. Defense attorney Shaw placed his hand on Breck's shoulder, a gesture of support even in defeat. Prosecutor Torres sat quietly, her face showing not triumph, but a kind of grim satisfaction that justice was being served. Judge Tuiasosopo thanked the jury for their service and informed them they would return the following week for the sentencing phase of the trial, where they would determine whether Breck would receive life in prison or death by lethal injection. She explained that the sentencing phase would involve additional evidence and testimony specific to the question of punishment. The jury would hear about Breck's background, his family history, any mitigating factors that might argue for life imprisonment. They would also hear the state's arguments for why the death penalty was appropriate given the circumstances of the crime. It was a preview of another emotionally difficult proceeding, the question of whether to end a teenage boy's life through execution, despite the moral complexities such a decision involved. The sentencing phase of Breck Miller's trial began on November 21, 2022, with the courtroom atmosphere even heavier than during the guilt phase. The jury had already determined Breck was guilty of murdering his mother with premeditation. Now they faced the agonizing decision of whether to sentence him to life in prison or death by lethal injection. Prosecutor Torres opened the sentencing phase by presenting victim impact evidence, calling friends and colleagues of Thessaly Harris to testify about the hole her death had left in the community. They described her volunteer work, her generosity, her passion for using her skills to help others. The testimony painted a picture of a life cut short at age 47. A woman who'd had decades of potential contributions ahead of her before her son ended everything with 7 blows from a rock. The cumulative effect was devastating, transforming Thessaly from an abstract victim into a fully realized person whose loss rippled through countless lives. The most anticipated and dreaded testimony came on November 22nd, when Chief Stellan Corwin was recalled to the stand to testify specifically about whether the jury should sentence his son to death. His appearance had changed markedly since his earlier testimony. He looked like he'd aged 10 years in the 3 weeks since the guilt phase, his hair grayer and his face carrying the weight of impossible choices. Prosecutor Torres's examination was brief and focused, asking Corwin to describe Thessaly's impact on his life, her role as a mother, and the void her death had created. Corwin spoke in a voice thick with emotion, describing 22 years of marriage, 2 children raised together, dreams and plans that would never be fulfilled. When Torres asked him directly whether he believed Breck should receive the death penalty for killing Thessaly, Corwin broke down completely. Through sobs that shook his entire body, Corwin said words that would be replayed in media coverage for weeks. "I loved my son. I still love my son. God help me. But what he did to Thessaly, to the woman who gave him life and loved him unconditionally, is unforgivable. She died terrified and betrayed by the child she would have given her life to protect. If the law says his punishment is death, then I cannot argue against it. I cannot protect him from the consequences of his choices anymore." The courtroom was silent except for the sound of crying from multiple spectators. Breck sat at the defense table, his expression showing not sadness but something closer to contempt, as if his father's testimony was one more example of betrayal rather than a devastating act of honesty and moral courage. That expression, captured by courtroom cameras, would become one of the defining images of the trial. Defense Attorney Shaw's cross-examination of Chief Corwin attempted to establish that his testimony was still influenced by the coercion of the immunity agreement. Shaw asked whether Corwin truly believed Breck deserved death or whether he was simply saying what prosecutors wanted to hear to avoid firearms charges. Corwin's response was unequivocal. The immunity agreement had forced him to testify, but his beliefs about Breck's culpability and deserved punishment were his own. Shaw then tried a different approach, asking Corwin to describe Breck as a child, to remind the jury that the defendant was still a teenager despite the adult nature of his crimes. Corwin acknowledged that Breck had been a normal child in many ways, that he'd had interests and hobbies and moments of kindness, but he also noted that looking back with the perspective of hindsight, there had been warning signs he'd missed or dismissed. Breck's increasing isolation, his obsession with online communities, his growing resentment toward his mother. The cross-examination's most dramatic moment came when Shaw asked Corwin if he'd ever imagined during Breck's childhood that his son would grow up to commit matricide. Corwin's answer was delivered directly to the jury, bypassing Shaw entirely. "No parent imagines their child will become a murderer. We see what we want to see, we explain away the warning signs, we tell ourselves it's just a phase or teenage rebellion. I failed Thessaly by not recognizing the monster growing in our home. But my failure as a father doesn't excuse what Breck did. He made choices. He planned and executed a murder. And he's shown no remorse, no growth, no indication he understands the magnitude of what he's taken from this world. If sparing his life served any purpose beyond satisfying my own selfish desire to keep my son alive, I would beg you for mercy. But I've seen no evidence that mercy would honor Thessaly's memory or protect anyone from future harm. At that moment, something unprecedented happened in the courtroom. Breck Miller smiled. It wasn't a nervous smile or a misunderstood facial expression. It was a clear, contemptuous smirk directed at his father, visible to everyone in the courtroom, including the jury. The expression lasted perhaps 3 seconds before Breck's attorney noticed and visibly reacted, touching Breck's arm in what appeared to be a warning to control his facial expressions. But the damage was done. The jury had seen in real time the narcissistic contempt that had driven Breck to murder his mother and plan his father's death. Judge Tuiasosopo had to call a brief recess as the courtroom erupted in murmurs and shocked reactions. Several jurors were seen shaking their heads in disbelief, and one woman on the jury appeared to be fighting back tears of anger. When court reconvened after the 15-minute recess, the atmosphere had shifted palpably. What had been a difficult sentencing decision had become, for many observers, a clear moral imperative. Breck's smirk during his father's devastating testimony had revealed more about his character than hours of expert psychological evaluation could have captured. It showed a complete absence of empathy, an inability to understand why his actions were wrong beyond the abstract knowledge that society condemned them. Defense attorney Shaw attempted damage control by calling a psychologist to testify that Breck's inappropriate affect was a symptom of his personality disorder rather than genuine contempt. But the jury's faces suggested they weren't buying the explanation. They'd seen what they'd seen, and no amount of expert testimony could unsee it. The defense's sentencing phase case focused heavily on Breck's youth and the possibility of rehabilitation, presenting evidence about brain development and the transformative potential of long-term incarceration. Dr. Kensington returned to the stand to reiterate his testimony about adolescent neurology, arguing that Breck's brain would continue developing until his mid-20s and that the person he was at 17 might be very different from the person he could become at 30 or 40. The defense presented statistics showing that some juvenile offenders, even those convicted of serious crimes, demonstrated genuine rehabilitation after decades in prison. Shaw argued that while Breck showed no remorse now, that didn't mean he would never develop the capacity for it. Life in prison would preserve the possibility of eventual understanding and regret, while execution would foreclose any chance of moral growth. But the prosecution's rebuttal in the sentencing phase systematically dismantled the defense's arguments for mercy. Prosecutor Torres presented evidence that Breck had shown no evolution in his thinking during the 8 months since his arrest. His conversations with other inmates, recorded per jail policy, showed him continuing to consume in-cell content through smuggled materials and to describe himself as a victim of maternal oppression. He'd referred to his mother's death as necessary in a conversation with a cellmate, showing no movement toward understanding or remorse. Torres argued that the defense was asking the jury to bet on a transformation that Breck had shown no capacity for. To spare his life based on hypothetical future rehabilitation, rather than any actual evidence of change. She reminded the jury that Breck had planned to murder not just his mother, but also his father, that his capacity for violence extended beyond a single tragic incident to a calculated plan to eliminate everyone he perceived as standing in his way. Torres's final argument in the sentencing phase returned to the manifesto, reading passages that described Breck's vision of freedom achieved through his parents' deaths. She asked the jury to consider what message they would send by sparing the life of someone who'd shown such calculated cruelty and complete absence of remorse. Would they be honoring Thessaly's memory or dishonoring it? Would they be protecting society or enabling the possibility of future harm? Torres acknowledged the moral weight of ordering an execution, particularly for a teenage defendant, but argued that some crimes were so heinous and demonstrated such fundamental depravity that the death penalty served both justice and deterrence. Breck Miller had not killed in a moment of passion or temporary insanity. He'd planned matricide for months, executed it brutally, and shown nothing but contempt for the victim, his family, and the court. If such a defendant didn't warrant the death penalty, Torres asked, then what crime ever would? The jury's sentencing deliberations began on November 28, 2022, after Judge Tuiasosopo provided detailed instructions on the standards for imposing the death penalty in Texas. The jury deliberated for 2 full days, far longer than their guilt-phase deliberations, suggesting the moral difficulty of the decision they faced. They requested to review Breck's testimony, the interrogation video, the manifesto excerpts, and video of his reaction during his father's testimony. The repeated review of evidence relating to Breck's demeanor and remorse suggested the jury was grappling with the question of whether his youth and potential for change outweighed his demonstrated callousness and lack of growth. On November 30, 2022, at 4:47 p.m., the jury informed the bailiff they'd reached a decision. The courtroom prepared for the final verdict that would determine whether Breck Miller would spend his life in prison or die by lethal injection for murdering his mother. Judge Kailani Tuiasosopo reconvened court at 5:15 p.m. on November 30, 2022, to receive the jury's sentencing verdict. The courtroom was even more crowded than it had been for the guilt phase verdict, with additional media representatives, law enforcement personnel, and community members who'd followed the case throughout its tragic progression. Chief Corwin sat in the front row of the gallery, flanked by Merritt and Thessaly's mother, all three looking exhausted by weeks of testimony and the emotional toll of watching their family's destruction become public record. Breck Miller sat at the defense table in his suit, his expression carefully neutral after his attorney had apparently counseled him extensively about controlling his reactions. The tension in the courtroom was palpable as the jury filed in, their faces showing the weight of the decision they'd made. The jury foreperson, Patricia Nguyen, stood when Judge Tuiasosopo asked if they'd reached a verdict on sentencing. She confirmed they had reached a unanimous decision, her voice steady but her hands trembling slightly as she held the verdict form. The clerk accepted the form and prepared to read it, the pause before she spoke, stretching out to what felt like eternity. We, the jury, having found the defendant guilty of murder in the first degree, hereby sentence Breck Miller to death by lethal injection, the clerk read, her voice filling the silent courtroom. The words were followed by audible gasps from spectators, sobs from Thessaly's family, and a kind of collective exhale from people who'd been holding their breath. Breck's reaction was minimal, a slight tightening around his eyes, but no dramatic breakdown or emotional outburst. He'd heard what everyone in the courtroom had expected to hear, but hoped against hearing. The clerk continued reading the sentencing verdict for the additional charges, 50 years in prison for abuse of a corpse, to be served concurrently with the death sentence, and additional years for obstruction of justice. The accumulation of sentences ensured that even if Breck's death sentence was somehow overturned on appeal, he would never walk free. He would spend the rest of his life, whether that ended in the execution chamber or in old age behind bars, paying for the choice he'd made to murder his mother on March 22, 2022. Judge Tuiasosopo thanked the jury for their service, acknowledging the difficulty of the decision they'd been asked to make and the moral courage it required to impose the ultimate penalty. She told them that victim services counselors would be available if they wished to discuss the emotional impact of their jury service. Judge Tuiasosopo then took the unusual step of addressing Breck Miller directly before formally imposing the sentence. She spoke for approximately 15 minutes, her voice carrying the weight of 12 years on the bench and countless difficult cases, but noting that this case stood apart. She described the evidence as overwhelming and irrefutable, the scientific proof of Breck's guilt as strong as any she'd seen in her judicial career. She acknowledged his youth, but noted that age did not excuse premeditation, careful planning, and the calculated cruelty of murdering one's own mother. She spoke about the manifesto, about the plans to kill both parents, about the complete absence of remorse demonstrated throughout the trial. Judge Tuiasosopo's voice broke only once when she described watching the video of Breck's smirk during his father's testimony as one of the most disturbing moments of her career on the bench. Then Judge Tuiasosopo spoke the words that would be quoted in every media account of the trial. "Mr. Miller, in 12 years as a judge, I have presided over murders committed in rage, in desperation, in the fog of mental illness. I have seen defendants whose crimes, while terrible, reflected moments of human weakness that we can understand, even if we cannot excuse. Your case is different. You planned your mother's murder for months. You researched how to kill her and avoid detection. You created an elaborate alibi. You struck her 7 times with enough force to fracture her skull, showing a level of violence that goes beyond anything necessary to end a life. And then, when caught, you showed no remorse, no understanding of the magnitude of what you'd done. You smirked when your father testified about your plan to kill him. You've treated this court, this jury, and your mother's memory with contempt." She paused, making eye contact with Breck, before delivering her final assessment. "This is the worst case I've seen in my time on this bench. The sentence of death is not only legally appropriate, but morally necessary." Judge Tuiasosopo formally imposed the sentence that the jury had recommended, ordering that Breck Miller be remanded to the custody of the Texas Department of Criminal Justice and executed by lethal injection at a date to be determined after the exhaustion of all appeals. She set automatic appeal deadlines per Texas law, noting that death penalty cases received enhanced scrutiny and multiple levels of appellate review. The reality, she explained, was that Breck would likely spend years, if not decades, on death row as his case worked through the appeals process, a timeline that reflected both the seriousness of the punishment and the legal system's desire to ensure no errors were made. For the families involved, this meant years more of living with the case, of potential retrials or hearings, of never being fully able to move beyond the tragedy that had shattered their lives on March 22, 2022. Chief Corwin's victim impact statement, read after the sentencing, provided a devastating coda to the trial. He'd written it in the days before the verdict, not knowing whether the jury would choose life or death, but needing to articulate his feelings regardless of the outcome. He described Thessaly as the center of our family, the person who held everything together, even when I was too focused on work to notice. He acknowledged his own failures as a father, his inability to recognize the warning signs of Breck's radicalization, his focus on his career, while Thessaly carried the burden of daily parenting. But he also affirmed that his failures didn't excuse Breck's choices, that every human being has agency and responsibility for their actions. He ended with a direct message to Breck. "I loved you from the moment you were born. I love you still, though that love is now poisoned by what you've done. I hope that somewhere in the years you have left, you find the capacity for genuine remorse. I hope you eventually understand the enormity of what you took from this world when you killed your mother. And I hope that understanding brings you no peace, because you deserve none." The courtroom cleared slowly after Judge Tuiasosopo adjourned the proceedings, spectators filing out with the subdued demeanor of people who'd witnessed something profound and terrible. Breck was led out by bailiffs, his hands cuffed behind his back, heading to a holding cell before being transported to death row at the Polunsky unit in Livingston, Texas. He would join approximately 200 other condemned inmates awaiting execution, living in 22-hour-a-day isolation as his appeals progressed through state and federal courts. The average time between sentencing and execution in Texas was approximately 11 years, meaning Breck would likely be in his late 20s if and when he was led to the execution chamber. He would have years to reflect on what he'd done, years to potentially develop the remorse that had been absent throughout his trial, though nothing in his behavior suggested such evolution was likely. Prosecutor Audrey Torres gave a brief statement to media outside the courthouse describing the verdict and a sentence as justice for Thessaly Harris and accountability for calculated premeditated murder. She acknowledged the difficulty of seeking the death penalty for a teenage defendant, but argued that the evidence of planning, the brutality of the crime, and the complete absence of remorse justified the ultimate punishment. Torres noted that Breck had been given every opportunity to show growth, to demonstrate the understanding of his actions, to express genuine sorrow for taking his mother's life. He'd shown none of these things, instead maintaining his posture as a victim throughout the trial. When a reporter asked if Torres had any regrets about seeking death for a 17-year-old, she responded, "My regret is that Thessaly Harris is dead, killed by the son she loved. My regret is that Chief Corwin had to testify against his own child. My regret is that a family has been destroyed by ideology learned in online cesspools. But I have no regrets about holding Breck Miller accountable for his choices." Defense attorney Marcus Shaw's statement to media acknowledged the jury's verdict while promising aggressive appeals. He argued that executing someone for crimes committed at age 17 violated evolving standards of decency, regardless of Texas statute, that the death penalty, in this case, constituted cruel and unusual punishment prohibited by the Eighth Amendment. Shaw noted that the Supreme Court had previously ruled against executing defendants who were under 18 at the time of their crimes in the 2005 Roper v. Simmons decision, and while that ruling had been somewhat narrowed by subsequent cases, he believed it provided grounds for appeal. He promised to pursue every legal avenue to save Breck's life, describing the case as emblematic of broader questions about how society should treat juvenile offenders and the role of online radicalization in criminal responsibility. It was clear from Shaw's statement that the legal battle was far from over, that Breck's execution, if it happened at all, was years, if not decades, away. The community reaction to the verdict and sentence was mixed, reflecting the moral complexity of executing a teenage defendant, even one who'd committed such a brutal crime. Many Austin residents expressed support for the death sentence, arguing that Breck's planning and complete lack of remorse demonstrated he was beyond rehabilitation. Online comments on local news sites reflected anger at Breck's ideology, horror at the manifesto's contents, and sympathy for Chief Corwin's impossible position. But others raised concerns about executing someone for crimes committed at 17, regardless of how horrific those crimes were. Criminal justice reform advocates pointed to the case as an example of how online radicalization created victims beyond the immediate crime, arguing that society needed better interventions to identify and help young people being drawn into extremist ideologies before they committed violence. The case's impact extended beyond the immediate verdict and sentence, sparking broader conversations about online radicalization, parental responsibility, and the adequacy of mental health resources for teenagers. School districts across Texas implemented new programs to identify students consuming extremist content online, training counselors and teachers to recognize warning signs of radicalization. Internet platforms faced renewed pressure to monitor and remove content that promoted violence against women, with the Breck Miller case cited as an example of how online rhetoric could translate into real-world murder. Parents' groups organized workshops on monitoring children's online activities using the Corwin family's tragedy as a cautionary tale about the dangers of unchecked internet access and the sophisticated nature of modern radicalization techniques. Thessaly Harris's legacy extended beyond her role as victim in a sensational murder trial. Her friends and colleagues established the Thessaly Harris Foundation in January 2023, dedicated to supporting financial literacy education and funding beekeeping programs in underserved communities. The foundation partnered with the Travis County District Attorney's Office to provide training for prosecutors and investigators in recognizing signs of domestic extremism and online radicalization. Thessaly's apiary was maintained by volunteers from the Austin beekeeping community, with the honey produced donated to local food banks in her memory. Her hives, particularly hive number 8, where the fatal bee had originated, became a kind of shrine, visited by people who wanted to pay respects to a woman they'd never met, but whose death had touched them through the trial's extensive coverage. Chief Stellan Corwin retired from law enforcement effective December 31st, 2022, ending a 23-year career under circumstances he could never have imagined. He relocated to a small town in West Texas, seeking privacy and distance from the Austin community where his family's tragedy had played out so publicly. In a final statement to the Austin Police Department, Corwin acknowledged his failures as a father and as a gun owner, taking responsibility for not securing his safe more carefully and for missing the warning signs of Breck's radicalization. He became an advocate for gun safety reform, speaking publicly about the importance of secure storage and regular auditing of weapons kept in homes with teenagers. His relationship with Merritt remained intact but strained, both of them struggling to rebuild their lives while carrying the knowledge of what Breck had done and planned to do. The bee that had solved the case became, in a strange way, a symbol of how justice could emerge from the smallest details. Dr. Helena Vasquez gave presentations at forensic science conferences about the case, using it as an example of how entomological evidence could provide timeline information unavailable through other means. The specific combination of species identification, pollen analysis, and time of death estimation represented a perfect application of multiple scientific disciplines working together. Young forensic scientists studied the case as an exemplar of careful observation, thorough analysis, and the importance of considering evidence that might seem insignificant to untrained observers. Detective Indigo Garcia's decision to notice and preserve a single dead bee on a suspect's shoe had made the difference between a case that might have gone unsolved and one that resulted in conviction and a death sentence. Breck Miller's time on death row unfolded as expected, with him filing the first of what would likely be many appeals in February 2023. His appellate attorneys, appointed by the court, raised issues including the admission of the manifesto as prejudicial, the coerced nature of Chief Corwin's testimony, the propriety of the Luna undercover operation, and the constitutionality of executing someone for crimes committed at age 17. These appeals would work through the Texas Court of Criminal Appeals and potentially the federal court system over years, if not decades. Meanwhile, Breck remained in isolation at Polunsky Unit, living in a 60-square-foot cell for 22 hours per day, allowed out only for showers and brief recreation periods in a concrete yard. Reports from prison staff suggested he continued to show no remorse, spending his time reading and writing letters to supporters he'd gained among online extremist communities who viewed him as a martyr to their cause. The final accounting of the case came not in courtrooms or prison cells, but in the changed lives of everyone it touched. Merritt Corwin dropped out of the University of Texas and eventually enrolled in a different school under a new name, seeking to escape the media attention and build a life separate from her brother's crimes. She struggled with survivor's guilt, knowing Breck had planned to kill both parents and wondering if she could have done something to prevent the tragedy if she'd recognized the warning signs. Therapy helped, but she would carry the weight of that March morning for the rest of her life. Chief Corwin lived quietly in West Texas, volunteering with a local youth program and speaking occasionally about gun safety and the dangers of online radicalization. He never remarried, telling friends that his capacity for that kind of relationship had died with Thessaly in the apiary on March 22, 2022. Detective Indigo Garcia continued her work in homicide, solving cases and building a reputation as one of Austin's most skilled investigators. But she retired from undercover work, the Luna operation having taken a personal toll that made continuing that type of assignment untenable. She thought often about Thessaly Harris, about a woman she'd never met whose death had resulted indirectly from Garcia's legitimate police work. The what-ifs haunted her. What if the operation had been shut down a week earlier? What if Thessaly had been told she was reporting a police sting rather than a real predator? What if the bureaucracy had moved faster to connect the dots? None of these what-ifs changed the reality that Breck alone bore responsibility for his mother's murder, but they complicated Garcia's relationship with her own role in the tragedy. Judge Kailani Tuiasosopo continued her work on the bench, presiding over countless other cases, but she would later say in interviews that the Breck Miller trial had changed her understanding of evil. She'd seen defendants who killed in rage, in desperation, in drug-addled confusion. But Breck's calculated planning, his complete lack of empathy, and his contemptuous smirk during his father's testimony represented something different, a kind of moral void that no amount of psychological explanation could fully account for. Her statement that it was the worst case I've seen became a defining quote of the trial, capturing the sense that Breck's crime stood apart not just in its brutality, but in its demonstration of fundamental human depravity. She became an advocate for judicial training in recognizing online radicalization, using her experience with Breck's case to educate other judges about the warning signs and the unique challenges these cases presented. The honeybees in Thessaly's apiary continued their work, oblivious to the human drama that had unfolded around them. Volunteers maintained the hives, harvesting honey each season and donating the proceeds to the Thessaly Harris Foundation. Hive number 8, source of the bee that had solved the case, remained productive, its colony thriving under careful management. Each spring, when the corpse lily bloomed, its grotesque flowers attracting the same species of carniolan bees to collect pollen just as their ancestor had on the morning of March 22, 2022, the volunteers would pause and remember. They remembered a woman who'd found peace in the ordered society of her hives, who'd understood the collaborative nature of bees as a model for human community, and whose life had been ended by the son who should have been her greatest source of pride and joy. The case file for the state of Texas versus Breck Miller eventually filled 23 archive boxes stored in the Travis County Courthouse, containing 847 pages of forensic reports, thousands of pages of testimony transcripts, exhibits ranging from a single dead bee to a 23-page manifesto, and video recordings that captured every moment of a family's public destruction. Lawyers, scholars, and journalists would reference this file for years, using the case as an example of forensic investigation at its finest and as a cautionary tale about the real-world consequences of online extremism. The bee, properly preserved in the evidence locker, remained available for any appeals that might require re-examination of the physical evidence. It was a tiny remnant of a life once lived, an insect that died doing what evolution had designed it to do, inadvertently becoming the key that unlocked justice for a woman who tended its hive with care and dedication. In the end, the case of Breck Miller stood as testament to multiple truths about modern American society. It demonstrated that justice could still be achieved through careful investigation and scientific evidence, that families could be torn apart by ideologies absorbed in the darkest corners of the internet, that the price of parental love could be testifying against one's own child, and that some crimes were so calculated and brutal that even youth couldn't serve as an excuse. Judge Tuiasosopo's words, "the worst case I've seen," echoed not just in the courthouse, but in the broader community's understanding of how far online radicalization could take a vulnerable mind and how completely it could destroy the people who should have been loved most. The death sentence handed down on November 30th, 2022, represented society's ultimate declaration that Breck Miller's actions had placed him beyond redemption, that some betrayals were so fundamental they warranted the most severe punishment the law allowed.